SJC-12720, Commonwealth v. Tomas Barillas.
Ms. Semmel, good morning.
Good morning, Your Honor. May it please the Court, Catherine Semmel on behalf of the Commonwealth. The Commonwealth's appeal from an order allowing the defendant's motion to suppress evidence seized from a cell phone. The cell phone was taken from the defendant's pocket upon his arrest for outstanding warrants. It was eventually searched at the Lynn Police Station with the consent of the defendant's brother, who had asserted ownership of the phone. The motion judge found valid consent, but suppressed the evidence based on circumstances preceding that consent search. The judge's ruling can be broken into two basic components. His finding that the phone was illegally seized and that the police made improper investigative use of that phone. Both rulings are being challenged by the Commonwealth. The seizure of the phone is an issue that can really begin and end with the justifiable security concerns that the police have.
Are you abandoning the inventory search?
No, Your Honor, I'm not abandoning it. It is an alternative basis for finding the seizure was correct, but I do think that the security concerns is a clearer argument. It doesn't involve subsidiary facts that the judge found that we are challenging.
When you say security concerns, are you talking about being concerned that the phone might be used as a weapon?
It might be used as a weapon or a means of effecting escape.
But that means everyone in this room is armed and dangerous, right?
The applicability of a finding that it's a means of escape or a weapon only comes into play when a person is subject to arrest.
But everyone's carrying a phone, so everyone's going to be subject to being pat frisked because they're carrying a phone?
I think that when an individual is under arrest, the officers can pat frisk them, and I think that any officer would be justified in removing a phone from a person being arrested before that person is transported.
Perhaps
Just to be, I'm sorry, go ahead.
perhaps as an inventory, right? But if someone is arrested and they're handcuffed, how are they going to use a phone to escape?
I think that the court has looked at the issue of a person being handcuffed in Clermy, which is probably mispronounced, but is cited in my brief. In that case, an individual was pat frisked, put in a police car, handcuffed, and then subject to another pat frisk in which they found something in the individual's groin. The court specifically said in that case that simply being handcuffed does not provide an absolute guarantee of safety for the officers. And the same is true in this case, that whatever difficulty you might have getting a phone in a pocket, it's certainly possible, and that it is a reasonable measure by police to remove the phone, to simply remove it from the individual's person before the person is being transported. And I would refer the court to the Blevins case, which is helpful in two specific ways. Blevins involves an individual who's being arrested for public drunkenness. Police pat frisk him, find a ring of 5 keys, put the keys up on the top of the cruiser, and put the defendant in the car.
But keys are different. I mean, you put keys in your hand and you punch somebody, basically it turned into a knife. I mean,
What if, counsel, it had been his wallet?
What if, I'm sorry?
What if it had been his wallet?
I think it would, I think there's a less good argument that a wallet is not a hard object. And I think when you look at Blevins, the court specifically focused on, and I quote, "A hard object found such as keys may be seized." They didn't say sharp, they didn't say jagged, they said a hard object. A wallet might be different in that way. A phone is a hard object. An iPhone is a substantial, heavy piece of equipment, which can be used as a weapon, as any hard object.
Let me ask you a question a little bit different. Let's say that you obviously search instance arrest, you feel the hard object, you can take a look at it. Let's assume, for the sake of argument, that you can inventory that, and you can do it right there. You don't have to wait until you get to the police station. You need to be able to, nonetheless, reach the point where the brother says that it's his phone.
Correct.
Before the video gets looked at.
Correct.
And that would require allowing the inventory to continue even up until questioning the brother?
Well, I think that the time period was very compressed, and that's certainly a factual finding by the judge. It's the only factual finding by the judge that we in fact challenge.
But that's important. Isn't it important that if you get to that point, and if it's a valid inventory, if that phone isn't inventoried right away, you need some reason why it isn't to be able to get to the consent of the brother.
If it's seized pursuant to an inventory, which are two different theories, then I would suggest that the officer gets to the police station. By his testimony, Trooper Wilson goes directly to speak to the brother and the father.
Now, Judge Lang's finding is, I think, different than that.
Judge Lang's finding is different. Judge Lang finds that the trooper was at the station for 20 minutes. I do think that, and I'll outline why, I do think that the judge mistook the testimony of the father, that they waited at the police station for 20 minutes for how long the trooper was at the police station. The only testimony from Trooper Wilson is that he went directly to speak to the father and the brother once he arrived at the police station. Judge Lang, of course, need not credit that testimony, but in fact, he said that he credits Trooper Wilson in every regard except where so stated. And in the one place where he discredited Trooper Wilson, he went to pains to describe why it was, and that had to do with when he entered the PIN code. So I would suggest that Judge Lang's finding that the trooper was at the station for 20 minutes before he went to speak to them is clearly erroneous and should not be relied upon by this court.
Okay, if I can go back to the search incident to arrest, and we're not talking about a pat frisk in the sense of a stop and frisk. We're speaking about a search incident to arrest, correct?
Correct.
Okay, so let's assume for the moment that we're not persuaded that the cell phone itself is dangerous enough that it requires it to be seized as a weapon. Your other argument is that it could be used to summon help.
Correct.
But what do we do with the statutory language which speaks only of a weapon that might affect his escape? Are you saying that the phone can be weaponized by asking for help?
I think that the court, and I'm not sure that it's really been in a way that is directly relevant as it might be here, but the court has interpreted that phrase as encompassing, and for instance, I quote Pfeiffer in my brief, weapons and instruments of escape. I think that the court, I think in other places I've seen weapons in quotes. I think that was in Blevins. That may be wrong. But I think the court has been clear that in interpreting that it makes no sense to limit instruments of escape to things that are independently classified as weapons. An instrument of escape is a weapon in a way, but I think the court has interpreted that term broadly in its own language and case law.
And would you go so far as to say that, I mean, every cell phone, of course, has the capacity to give a text. Would it be your view that would mean that it would always be something that you would seize instant to arrest, or would it be limited to crimes of violence or some other more limited types of crimes?
I wouldn't foreclose it being the possibility that it could be seized in any case. I think that it transcends the particular type of crime, but in this case, certainly, the specific facts of this case provide heightened concern. This was an individual who was holed up in his apartment, who refused to come out when police arrived, kept his brother in there when police were there, was found eventually hiding under a tarp in the basement, and was a person of interest in a murder which, of course, he's since been charged. So officers certainly had heightened concerns in that case. If the court were inclined to view it more narrowly, the circumstances in which it's reasonable, objectively reasonable to seize a phone, I think this case certainly qualifies.
What do you make of the Lynn inventory versus the state police inventory policy? If you're able to get over the 20-minute finding issue.
Right. I think that when The trooper was very upfront when he testified, and the judge specifically asked him, was he really in your custody? Was he in Lynn custody? And he said that he was in Lynn custody. But it is not at all uncommon for officers such as the CPAC detective or other officers in a multi-jurisdictional task force to work together to bring an arrest. And I would suggest that the custody should be broadly construed by the court in this instance. It should encompass anyone who's involved in the arrest. That it just makes no sense to limit the actions of other officers who are there helping with the arrest by saying that because he's technically going to be booked in Lynn, nobody else has authority in this way. And I think the purpose of the inventory search or the inventory policies is to provide that officers are acting pursuant to a written established policy. And that purpose is satisfied whether it's a state police detective or a Lynn police detective, regardless of where he's going to go to be booked.
Yeah, I don't think anybody's saying that there can be, if a state police trooper seizes it, then it can never be part of an inventory. I think the argument is that when you bring somebody to the Lynn Police Station, then the Lynn Police inventory becomes the operative inventory.
Which I think, I'm not sure, I don't think that, I'm sorry. I'm not sure that what difference that makes in this case, perhaps.
Well, the problem is it might make a difference because the judge did not allow the evidence to be reopened, I believe, in order to allow in the Lynn Police inventory. So that's not part of the evidence in this motion to suppress.
All right. I see your Honor's point. I think because we never got to that point, we never got to the point of the inventory, that I don't think is critical in this case. If it was proper for him to seize it under his inventory policy, then it was proper for it to be in his pocket. And I would just suggest that it was reasonable for the trooper to go talk to the witnesses who were there at the police station at the time that he did. And certainly the court has held that technical procedural deficiencies do not overcome an otherwise valid inventory search. Failure to fill out the paperwork, I'm sure the paperwork would have been filled out. And Trooper Wilson testified when he was recalled that he didn't fill out the inventory forms because he went directly to see the son and the father, and he quickly learned that the phone belonged to the brother.
Now, do we know what the inventory indeed was for this particular defendant? I mean, was there anything on his person?
There was nothing else on his person.
So
Trooper Wilson.
the only thing on his person was the phone?
Correct.
No wallet, no money, no keys, no nothing?
No, nothing. Trooper Wilson specifically testified to that.
So how do we find, if we were to say that the appropriate inventory policy is the Lynn policy, how do we get there when the judge did not allow into evidence the inventory policy from Lynn?
If the court is has to rely on the Lynn policy, then I agree, you can't get there. We're stopped from getting there. But I don't think you need to get to the Lynn policy to find that it was proper in this case.
And how do we do that?
I would say that the property was properly seized pursuant to the state police inventory policy or for security concerns, and that it was properly being transported to the police station by the trooper, who very quickly learned that something else was going on with the phone. I don't think you need to get to the Lynn policy to find that it was appropriately seized, appropriately in the trooper's possession at the time he spoke to the brother.
Well, there's a number of cases that allow with joint investigations flexibility. But here, why isn't the answer as simple as whatever police department you're in is the inventory policy that controls?
I think that the difficulty is when you have multiple officers from different jurisdictions or under different departments working together. Obviously, when you get to the police station, it's very easy for that station's policy to control. At the scene, you have a number of officers working together. CPAC and state and local police work together all the time in homicide investigations. besides, task force and things like that, at the scene, I think you need to make some allowance for the officers to act upon the policies that they are aware of. And it would be disingenuous, it would have been disingenuous for Trooper Wilson to come in and say that he was familiar with all the Lynn police policies or the Lawrence police policies. I think what we can reasonably expect is that officers are familiar with and follow the policies of their department. And when they're working with another jurisdiction, I think that they still need to follow their own policies.
And what does the state police policy say when you see something at the scene of the crime as to when you're supposed to hand it over to the booking officer?
I don't think that it makes clear when you're supposed to hand it over to the booking officer. I think it makes clear that you are supposed to hand it over to the booking officer and fill out forms, which takes me back to my argument that the judge was wrong, that the officer was at the station for 20 minutes, and that his failure to have completed the paperwork did not undermine the validity of the inventory search.
All right, thank you.
Thank you.
Mr. Spurlock.
Good morning, may it please the court. Matt Spurlock for Thomas Barillas. With me is Attorney Reagan, trial counsel in this case. Judge Lang's well-reasoned decision correctly suppressed the evidence of the warrantless seizure of the phone in this case, and this court should affirm for at least 3 reasons. Now, at the threshold, the Commonwealth has failed to establish either of the narrow exceptions to the warrant requirement. It failed to introduce any valid inventory policy for an arrestee in the custody of the Lynn Police and booked at the Lynn Police Station. But even if the state policy somehow applies on these facts, Trooper Wilson failed to comply with its terms. The Commonwealth also failed to establish that the phone was a weapon amenable to use for an escape or to resist arrest.
How did Trooper Wilson fail to comply with the state police policy?
Excuse me, Justice Gaziano?
How did Trooper Wilson fail to comply with the state police inventory policy?
Well, the state police inventory policy would require, I think, on a fair reading, inventorying at the barracks. It's supposed to be the barracks. It's a state policy. And if it doesn't, as I explained in my brief, then the policy itself is unconstitutional. That policy, I don't think, can fairly be read to apply for inventorying at the scene of an arrest. That's not.
So if a state police officer arrests somebody and the person has a Rolex watch and is on his wrist or a big wad of money on him, the police officer can't take that wad of money and say, I don't want him to have it in his pocket because who knows what transport officers are going to be there. We don't want any liability. They hold it, and then they go back to the station and they inventory it. That's okay, right?
No, if the wad of money is evidence of a crime of arrest, they can seize it under 276.
I get that.
But I don't think they can.
Answer my question.
I don't think they can typically. Well, the state police policy, as I read it, and certainly the Lynn police policy, which is not in evidence but is in the record appendix, neither of them would allow for that sort of inventorying at the site of the arrest.
No inventory can happen at an arrest.
Yes, and this court has explained that it's important for inventory policies to be clear. So if an inventory policy is so ambiguous as to allow the officers to decide whether to inventory at the scene of the arrest or anywhere in between or at the station, that policy itself, I think, is questionable in terms of the Constitution. That just allows too much discretion. The point of an inventory policy is supposed to be to protect the police against claims of theft and to keep contraband out. But if you allow the police to inventory it at the site of the arrest, that doesn't serve those purposes, because what could happen in between? This case explains the problems with that. We have an unconstitutional investigative use that was not supposed to take place without a warrant, that took place because the officer, I suppose on the Commonwealth's theory, seized it incident to an inventory, or seized it as an inventory at the site. I don't know of any court that allows the inventory to happen at the site of the arrest or any case. I do cite a case from California that specifically rejected this so-called accelerated inventory, and I don't think it would be wise for this court to endorse that sort of theory. It certainly would be novel as far as the cases that I've seen.
But what about if the person has a backpack and the police officer grabs the backpack, and then brings it to the booking officer.
Yeah, so a backpack might potentially contain a weapon. It might be, as in Mauricio, the backpack itself could be evidence of the crime of arrest. So there are other
And
non-inventory reasons.
let's assume the police officer is not seizing it for that purpose, but seizing it purely because it may contain belongings which need to be inventoried.
Well, I think that seizure would probably not fall under inventory. I mean, I think it's quite difficult for, a defendant to sit in the back of the cruiser with the backpack on his back. So I think the officer can, take it off him while he's handcuffing him and put it beside him, carry it in the cruiser.
So there's a comfort exception?
It's not a comfort exception, it's just common sense. I mean, you can't.
Telling us a second ago that that's not possible. Now you're telling us there's a comfort exception. Which one is it?
I didn't agree with your example of the wad of money or the Rolex, but when it's something that you need to do physically, you put the backpack beside him and in the back. I think
As long as
that,
we're talking about common sense, though, is it really, doesn't it defy common sense when you arrest somebody for a crime to just have them have their cell phone with them in the back seat?
I don't think so, Your Honor. I think that, there are exceptions, and they're narrowly delimited to warrantless searches. And taking a cell phone or any other property off someone simply doesn't fall within the inventory exception, and it's not a weapon. Now,
I'm having trouble with the inventory
Okay.
part of it, just like I'm having trouble with, leave the backpack in the back as well. I mean, it just sort of seems to me to defy common sense to say, okay, well, I see you have a cell phone, we'll grab that from you and inventory it when we get back to the station in 5 minutes.
I think what the Lynn inventory policy, which was the policy that should have governed here but was not in this case, what that says is that you inventory at the station. That's very clear from the policy. The state policy, which is in this case but does not apply to this defendant, is, in my view, unconstitutionally vague, because if read as the Commonwealth does, it would allow a seizure at any point from arrest up to the booking, up to where you're booked, and it just simply, that doesn't further any of the purposes. You're not, marking down what's being taken from the person. You're, as happened here, putting stuff in your pocket, and then who knows what happens between at the set of the arrest and when it's supposed to be booked. So that's the problem with that. But I think even under the state policy, which again doesn't apply here, I think that's,
The state policy it does seem to cover this. It says, members are authorized to search a subject and remove any property from their clothing or person, and search the contents of any outer garments, bags. Members searching a subject shall then inventory any document, record, now, you got an argument on record inventory and an SP2 custodial property inventory. If possible, inventory items in the presence of the subject. Doesn't that cover?
I think it could be read like that, but those are all the steps. The whole protocol there is supposed to happen at the barracks with the booking officer. And it can't, in my view, it can't happen, part of it at the site of the arrest, some of it in the middle, and the other at the end.
Do you win because it's not clear, or do you win because it is clear in your favor?
All of the above. I mean, I think it's
Can't win on both. You got
well, I think if you read it as the Commonwealth does, I think it's unconstitutional. I think it's just too vague. We can't have that kind of discretion. You can't have a policy that allows the officers to decide where they're going to search it, when they're going to search it, and how they're going to search it. The whole point of inventory policies is to have precision. Now, there might be a policy, not this policy, that applies to the defendant, again, not this defendant, that would say inventory searches have to happen at the site of the arrest. That's not this policy, and that would be for another day for this court to decide whether such a policy would be unconstitutional. The California Supreme Court has rejected that, and I think it would make sense to reject that.
But what if we agree with you that the Lynn inventory policy is the appropriate policy? Did the judge err in not allowing that to come into evidence?
Not at all, and the Commonwealth is not appealing from that, so that's simply not available to the Commonwealth. They specifically declined to appeal from that ruling. So I think the court needs not inquire any further. Even if you were to look at that policy, the officers did not comply with that policy here, because that policy is very clear that the inventory search happens at the station. It's on the first page of the policy. Also note that in the last page of the policy, the last paragraph, disclaims any joint application with other policies. So when the Lynn policy applies, no other policy applies.
So Going back to the backpack example, the person has a backpack, they grab the backpack, they should bring it to the station at booking, they should say to the booking officer, here's the backpack I seized, and then the backpack will then be inventoried in a form prepared pursuant to the Lynn policy.
That's what the Lynn policy says, and then depending on the Lynn policy, I haven't studied it that closely because it's not an issue in this case. I don't recall if it allows for opening of closed containers like that or not. I mean, that's the problem. Some policies do, some policies don't. So if we allow the officers, as the Commonwealth is arguing here, to decide which policy they're gonna follow, you might have a joint investigation with, 4 different jurisdictions. And okay, so this is more beneficial for us here. We're going to seize at the site and inventory it pursuant to the state policy, and then here the Lynn policy will apply.
What if it's the arrest happens, brought back to the Lynn Police Station, but it's clear that the officer who's going to be in charge of chain of custody is with the state police? Nonetheless, the inventory policy is through the Lynn Police Department rather than waiting to get back to the state police.
There's a trooper working in the Lynn Police State Department that is receiving. I'm not sure, Your Honor. That's far afield from the facts in this case.
Well, the reason for the question is a practical one. It may not be that the jurisdiction, when you have a joint investigation or in a murder when it's a matter of course, the police department where the person's booked is not necessarily going to be responsible for the chain of custody as it relates to certain evidence.
I think it's wherever the defendant is booked. That's, the Lynn Police, if an arrestee is brought to the Lynn Police Station, Lynn Police policy should apply. That's what the policy says, and only that policy should apply. When he's booked there, presumably by a Lynn police officer, I'm not aware of a situation where a state trooper would be working at the Lynn Police Station booking defendants there, but that may be the case. That may be a different case. I don't think you need to decide that here. What is clear here is that the Commonwealth utterly failed to establish that this inventory policy applied. And the Lynn police policy is not in the case, and even if it was, they didn't follow that policy.
Does it matter that he's assigned to the Essex DA's office? The police officer's assigned to the Essex DA's office, or that's my memory of?
No, what matters is where the defendant was booked. That's inventory policies, unless.
In cases say that directly, or you're putting that together?
That's, all the cases, if you read them together, the point of this is it's supposed to happen at the police station. Now, there is an alternate theory hanging out there of what's called an accelerated booking search, and I spend a paragraph of that in my brief talking about it. The Commonwealth doesn't really raise it, but it's been rejected as far as I can tell everywhere. If there were another policy that specifically allowed for such an accelerated booking search, that could be allowable. That would be a different case. And there would be procedures which would mandate that happened there. Now, the Commonwealth in its brief says that the officer was required to search there. If that's true, the trooper was required to inventory it there, then it would be, again, a violation of that booking policy to wait until you get to the barracks to inventory it there. Policies are supposed to be clear. There's not supposed to be room for discretion.
And when you say the Commonwealth has not appealed from the judge's denial of the motion to reopen the evidence, is that because the notice of appeal applies only to his decision and not to his denial of that motion?
No, it's a decision they made. It's on footnote 2 of their brief, and they agreed with the judge. They thought it was within his considerable discretion to deny that motion to reopen and reconsider, and they chose not to appeal from that. I mean, I think, obviously think that decision was correct. It's on Record Appendix 97 to 101, the judge's decision. It's quite well reasoned. He analyzed not only whether that policy was available, but also whether substantial justice mitigated in favor of allowing it, and no on both grounds. He explained that the reason they wanted to get it in to advance an inevitable discovery argument was also not available because on these facts you couldn't show that the consent would have inevitably came. So they've also waived the inevitable discovery argument as well.
So let me turn you then to a search and seizure. So we've got an individual who I believe at the time they understood to be a member of a gang. I think they had that information at the time of the arrest. Is it an appropriate concern to not want a gang member to have a cell phone to potentially text fellow gang members to say, I'm being transported to the police station?
I have a few responses to that, Chief Justice Gantz. That issue is not properly raised here. The Commonwealth raises it at one sentence in a footnote in their appellate brief, so it's simply not preserved. Second, we have a statute in Massachusetts that limits, it sets the floor for searches incident to arrest. And that statute is very clear. It's supposed to be weapons that can effectuate escape or resist arrest. It's not, I don't think it's available for this court to construe that statute as you suggested. If it were just a constitutional rule, you know, under the rule of reasonableness, this court could create a new exception. I would note that the Supreme Court rejected that very argument in Riley v. California, and
Well, that was a search for evidence
well,
in Riley.
yes, it was, but they rejected in dicta, albeit, but there's a whole paragraph in that rejecting the idea that California and the United States government raised that an alternate reason for seizing the phone could be because of communications with Confederates. So
What about, you know, the chief raised the issue of texting. What about if it's a wireless or hands-free?
that's my point.
Siri, call my gang member.
That's my point. We have a statute here, and the statute says it has to be a weapon that can effectuate escape or resist arrest. Now that sort of communication does not turn the phone into a weapon. Again, that issue is completely waived because it was not raised below, and the Supreme Court rejected that very argument in Riley. So even if we were deciding this case under Article 14,
Okay, Riley didn't talk about escape, though, right? That wasn't
No.
that wasn't the holding in Riley.
no, it's dicta in Riley, but there's a whole discussion.
So I guess you agree with that. That wasn't the holding in Riley.
I agree with that. Yes. But I think it's persuasive, at least, discussion about that reason for seizing a phone. I would like to, if I could, just get to the investigative use of the phone. You know, because if the court somehow finds that the Commonwealth can establish one of these exceptions, that's what we get to. And I think here, I mean, clearly the use was investigative. The officers questioned Jefferson, 13-year-old Jefferson, about the phone while displaying it to him. They typed the passcode into the phone. This is, I mean, there's no other way to characterize these facts except for an investigative use. And I think that's what Blevins teaches in the context of incidents to arrest when the police are inserting the keys to figure out what car it is. And that's also what Mauricio just 2 years ago teaches in the context of an inventory search with a digital camera.
That's all post-consent. The issue is what happens prior to the consent.
Exactly. This is
But the investigatory search happens post-consent.
No, the investigatory search happens before the consent. That's the whole point here. The search, the forensic.
He talks to the kid and says, "No, that's my cell phone in your pocket," and right? That's the issue.
I disagree. There's consent. There is valid consent. We're not challenging that here. We're not cross-appealing from that. And there's a forensic and manual search. But before that consent, and what tainted that consent, there's an investigative use of the phone. That's what Judge Lang found. That investigative use included displaying the phone to the brother, asking questions about it, typing in its passcode and PIN, confirming that the PIN opened the phone, and then at the recorded interview, asking him more questions about it, questions about the screen, why it was cracked, questions about its history, its usage. That whole package of facts I just described, that's investigative use. And even if one of the two exceptions applies, that sort of investigative use is not allowed before the consent. So to get to that consent, there's all these facts which created an investigative use. And the Commonwealth says, well, they were verifying. I mean, that's conceding the issue. To verify is to investigate. When you have an inventory search, you're allowed to see something that's obvious, but you're not allowed to delve into that. You're not allowed to do research about what it says in the pills. You're not allowed to note the numbers, the bank account numbers. And you're not allowed to notice that the keys are GM type and walk around and insert the keys into different cars and figure out what car it is. That's exactly what happened here under both those. So even if somehow the Commonwealth can establish an exception, there's an independent basis for suppressing the second basis that Judge Lang found.
All right, thank you.
I ask that you affirm. Thank you.